Welcome back, everyone. Let's jump straight into today's advanced CPD explainer. We're diving headfirst into the high-stakes world of alternative dispute resolution, ADR, in construction projects. We're going to unpack standard forms like FIDIC and NEC, look at the very real commercial implications, and honestly, figure out how to ideally avoid these messy disputes in the first place. So here's the multi-million-dollar question that keeps commercial managers and contractors up at night. What happens when the project grinds to a halt, but those bills just keep rolling in? Cash flow is literally the lifeblood of construction, right? When a massive disagreement over a variation, a delay, or a defect completely stops site progress, the financial pressure is just absolutely immense. That's exactly why mastering how to navigate and, more importantly, de-escalate these situations isn't just nice to know, it's an absolute must-have survival skill. To tackle this, we're going to climb what I like to call the escalation ladder. We'll start with avoidance and early action, move up to mediation and conciliation, hit DAB, DAAB, and adjudication, talk about solving technical disputes, jump into arbitration and litigation, and wrap the whole thing up with multi-tiered dispute clauses.
All right, let's kick things off with Section 1, avoidance and early action.
Listen, the absolute cheapest and fastest dispute is the one that never actually starts. It's that simple. Proactive avoidance begins right on day one in your project brief. Using frameworks like the REVA Plan of Work ensures your strategic definitions are crystal clear from the get-go to head off those early misunderstandings. But hey, this is construction. Friction's gonna happen. When it does, tools like Early Neutral Evaluation, or ENE, act as this fantastic reality check. It gently nudges both parties towards a sensible settlement before time and money just vanish into thin air. And if things do escalate to a formal decision by an engineer or a board, well, standard contracts usually build in a mandatory cooling-off window. Take that 56-day amicable settlement period, for example. It literally just exists to let cooler heads prevail before someone hits the panic button.
Moving right along up the ladder to Section 2, mediation and conciliation.
So, what if you just can't sort it out yourselves? You bring in a third party, but, and this is key, you still keep control over the final outcome. Now, there's a ton of confusion in the industry between these two methods, so let's clear it up right now. In mediation, an independent third party facilitates the conversation. They're often shuttling between rooms, speaking to each side individually, trying to slowly narrow the gap. Conciliation, on the other hand, is much more direct. The conciliator drags everyone to one table and actually hands over their own proposed solution to the dispute. So remember, one facilitates, the other actively advises.
Next up, Section 3, DAB, DADAB, and adjudication.
Okay, so facilitation didn't work. Now we step it up to statutory adjudication. Established over in the UK by the 1996 Act, this gives any party to a construction contract the absolute statutory right to refer a dispute to an impartial adjudicator literally at any time. It's built from the ground up to be swift and cost-effective. Though, quick aside here, keep in mind this specific statutory right doesn't apply if one of the parties is a residential occupier. Just a little trap for the unwary there. The real crucial point here is how this plays out in reality. Statutory adjudication runs on a wildly strict 28-day timeline. Sure, you can extend it slightly if everyone agrees, but it moves fast. Your dispute gets evaluated by heavy hitters, seasoned industry experts like RICS adjudicators who actually understand the messy technical realities of a construction site. They look at the facts and issue a decision that is binding, meaning you have to comply with it immediately, which is exactly what keeps the cash flowing on a live job. But, and this is a huge but, it's not final. If you're absolutely furious with the outcome, you can technically drag it through arbitration or court later to try and get it overturned. Let's see how this actually looks in international standard forms. Take the FIDIC 1999 timeline for a dispute adjudication board, or a DAB. Once the dispute is officially referred, both parties throw their submissions into the ring, and the DAB has exactly 84 days to hand down a decision. If a party issues a notice of dissatisfaction, basically saying, "No way, I don't accept this," it immediately triggers that vital amicable settlement period. You get at least 56 days to cool off and negotiate before anyone is even allowed to think about initiating formal arbitration. Now check out this subtle but honestly game-changing shift in the 2017 FIDIC update. The acronym suddenly gains a letter, DABB, Dispute Avoidance and Adjudication Board. The 84-day decision window and those strict 28-day notice periods, yeah, they're pretty much exactly the same, but this newer standard explicitly bakes in a proactive avoidance layer. The board is actually empowered to get in there early, manage the friction, and help the parties completely avoid the dispute before it ever reaches the point of needing a formal binding decision. It's a brilliant shift. All right, let's pivot a bit. Section 4, Solving Technical Disputes.
So what happens when you're fighting, but it's not over some broad, sweeping legal breach? What if it's just a highly specific, super technical question? That's where expert determination comes in. This is a fully private process where you appoint an independent technical guru to investigate one narrow, isolated issue. We're talking things like the exact dollar value of a tricky variation or whether a specific batch of materials actually met the precise contract specs. You are effectively bypassing the lawyers completely and going straight to a subject matter expert who decides based purely on their own technical know-how.
The real beauty of expert determination? It's lightning fast, it's relatively cheap, and it completely spares you from the nightmare of a long trial drowning in paperwork. Plus, these decisions are almost always binding and notoriously difficult to challenge. But let's do a quick reality check here. It is absolutely useless, literally pointless, for broad, messy claims like corporate misconduct or complex breaches of trust. It only works if both of you can actually agree on exactly who the expert should be and exactly what narrow technical question they're supposed to answer.
Which brings us to the very top of our ladder. Section 5, Arbitration and Litigation.
When every single early intervention and adjudication trick in the book has failed, you hand over the keys to the formal legal system. Now, litigation is your traditional, highly formal, and notoriously expensive public court process. And fun fact, courts today will often actively penalize you if you haven't bothered trying ADR before showing up in front of a judge. Arbitration, though, is generally the heavyweight champion in the construction sector. It's completely private and results in a final binding award. The grounds for challenging it are incredibly slim. Basically, you have to prove some catastrophic procedural error or blatant bias. It keeps all your dirty laundry and sensitive technical data out of the public eye, and it's usually just a much more streamlined beast than litigation.
And finally, let's look at how this all ties together in Section 6, Multi-Tier Dispute Clauses.
So how do modern standard forms actually stitch all these different methods together into one coherent safety net? They use a tiered escalation procedure. Basically, they legally force you to exhaust all your cheap collaborative options first. Step 1 is almost always mandatory negotiation, that amicable settlement phase we talked about. If you can't hash it out, you get pushed to Step 2, bringing in a mediator for some third-party facilitation. Only if that completely and utterly breaks down are you allowed to unlock Step 3, formal arbitration or litigation.
We're also seeing these fascinating hybrid approaches popping up everywhere, like MedArb. In this setup, your dispute kicks off as a totally standard mediation. But if you just can't strike a deal, the whole process flips. The mediator, or sometimes they bring in a fresh face, suddenly steps into the shoes of an arbitrator to make a hard, binding decision based on the facts. Now, on paper, this saves a massive amount of time and money by smashing the two phases together. But huge caveat here, guys, it requires incredibly careful handling. Think about it. If that mediator turned arbitrator heard all your secret, confidential concessions during the mediation phase, you have to be absolutely certain neither party feels like the final binding award was tainted by bias.
I love this matrix. When you're sitting down drafting your next contract, use this as your mental checklist moving forward. Look, negotiation and mediation, huge flexibility, super low cost, but entirely non-binding. Adjudication, incredible speed, keeps the cash flowing on site, but remember, it's not final. Expert determination is your go-to sniper for fast, binding technical decisions. And arbitration, that's your heavy artillery, your final, fully enforceable backstop when absolutely all else fails.
So, as we wrap up today's explainer, I really want to leave you with a provocative thought. Go back to your commercial teams and ask yourselves this. Are your current contracts truly structured to de-escalate conflicts through layered ADR? Or are your dispute resolution clauses inadvertently fast-tracking you straight toward an outrageously expensive courtroom? Seriously, take the time this week to audit your standard forms. Apply what we've unpacked today and take back control of your project's risk profile. It's been an absolute blast going through this with you all. Thanks so much for joining me, and we will see you next time.